Chapter 7. The Economics of Big Business. Competition always has been and always will be troublesome to those who have to meet it. Frederick Bastiat. Big business can be big in different ways. They can be big absolutely, like Walmart, with billions of dollars in sales annually, making it the biggest business in the nation, without selling more than a modest percentage of the total merchandise in its industry as a whole. Other businesses can be big in the sense of making a high percentage of all the sales in their industries, as Microsoft does with sales of operating systems for personal computers around the world. There are major economic differences between bigness in those two senses. An absolute monopoly in one industry may be smaller in size than a much larger company in another industry where there are numerous competitors. The incentives and constraints in a competitive market are quite different from those in a market where one company enjoys a monopoly, and such differences lead to different behavior, with different consequences for the economy as a whole. Markets controlled by monopolies, oligopolies, or cartels require a separate analysis. But before turning to such analysis, let us consider big businesses in general, whether big absolutely or big relative to the market for their industry's products. One of the general characteristics of big businesses has already been noted in Chapter 6, economies of scale and diseconomies of scale, which together determine the actual scale of production of companies that are likely to survive and prosper in a given industry. Another of the general characteristics of big businesses is that they typically take the form of a corporation, rather than being owned by a given individual, family, or partnership. The reasons for this particular kind of organization and its consequences require examination. Corporations. Corporations are not all businesses. The first corporation in America was the Harvard Corporation, formed in the 17th century to govern America's first college. Corporations are different from enterprises owned by individuals, families, or partners. In these other kinds of enterprises, the owners are personally responsible for all the financial obligations of the organization. If such organizations do not happen to have enough money on hand to pay their bills, or to pay any damage resulting from lawsuits, a court can order the seizure of the bank accounts or other personal property of those who own the enterprise. A corporation, however, has a separate legal identity, so that the individual owners of the corporation are not personally liable for its financial obligations. The corporation's legal liability is limited to its own corporate assets, hence the abbreviation LTD for limited liability, after the names of British corporations, serving the same purpose as Inc., Incorporated, after the names of American corporations. This limited liability is more than a convenient privilege for corporate stockholders. It has major implications for the economy as a whole. Huge companies, doing billions of dollars worth of business annually, can seldom be created or maintained by money from a few rich investors. There are not nearly enough rich people for that to happen, and even those who are rich would seldom risk their entire fortune in one enterprise. Instead, gigantic corporations are usually owned by thousands or even millions of stockholders. These include not only people who directly own shares of corporate stocks, but also many other people who may never think of themselves as stockholders, but whose money paid into pension funds has been used by those funds to purchase corporate stock. Directly or indirectly, about half of the American population are investors in corporate stocks. Like many other things, the significance of limited legal liability can be understood most easily by seeing what happens in its absence. Back during the First World War, Herbert Hoover organized a philanthropic enterprise to buy and distribute food to vast numbers of people who were suffering hunger and starvation across the continent of Europe, as a result of blockades and disruptions growing out of the military conflict. A banker whom he had recruited to help him in this enterprise asked Hoover if this was a limited liability organization. When Hoover said it was not, the banker resigned immediately, because otherwise his life savings could be wiped out if the organization did not receive enough donations from the public to pay for all the millions of dollars worth of food that it would buy to feed all the hungry people across Europe. The importance of limited liability to those particular individuals creating or investing in corporations is obvious, but the limited liability of stockholders is of even greater importance to the larger society, including people who do not own any corporate stock nor have any other affiliation with a corporation. What a limited liability does for the economy and for the society as a whole is to permit many gigantic economic activities to be undertaken that would be too large to be financed by a given individual, and too risky to invest in by large numbers of individuals if each investor became liable for the debts of an enterprise that is too large for all its stockholders to monitor its performance closely. The economies of scale and the lower prices which large corporations can achieve as a result, and the correspondingly higher standards of living resulting from these economies of scale, enable vast numbers of consumers to be able to afford many goods and services that could otherwise be beyond their financial means. In short, the significance of the corporation in the economy at large extends far beyond those people who own, manage, or work for corporations. What of creditors who can collect the debts that corporations owe them only to the extent of the corporation's own assets, and who cannot recover any losses beyond that from those who own the corporation? The Limited, or Inc., after a corporation's name, warns creditors in advance, so they can limit their lending accordingly and charge interest rates adjusted to the risk. Corporate governance. Unlike other kinds of businesses, where those who own the enterprise also manage it, a major corporation has far too many stockholders for them to be able to direct its operations. Executives are put in charge of corporate management, hired and, if need be, fired by a board of directors who hold the ultimate authority in a corporation. This arrangement applies beyond business enterprises. Colleges and universities are usually also managed by administrators who are hired and fired by a board of trustees, who hold the ultimate legal authority, but who do not manage day-to-day operations in the classrooms or in academic administration. Like limited liability, the separation of ownership and management is a key characteristic of corporations. It is also a key target of critics of corporations. Many have argued that a separation of ownership and control permits corporate managements to run these enterprises in their own interests, at the expense of the interests of the stockholders. Certainly, the massive and highly publicized corporate scandals of the early 21st century confirm the potential for fraud and abuse. However, since fraud and abuse have also occurred in non-corporate enterprises, including both democratic and totalitarian governments, as well as in the United Nations and in non-profit charities, it is not clear whether the limited liability corporation is any more prone to such things than other kinds of organizations, or any less subject to the detection and punishment of those who commit crimes. Complaints about the separation of ownership and control often overlooks the fact that owners of a corporation's stock do not necessarily want the time-consuming responsibilities that go with control. Many people want the rewards of investing without the headaches of managing. This is especially obvious in the case of large stockholders whose investments would be sufficient for them to start their own businesses if they wanted management responsibilities. The corporate form enables those who simply want to invest their money without taking on the burdens of running a business to have institutions which permit them to do that, leaving the task of monitoring the honesty of existing management to regulatory and law enforcement institutions, and the monitoring of management efficiency to the competition of the marketplace. Outside investment specialists are always on the lookout for companies whose management efficiency they expect to be able to improve by buying enough stock to take over these corporations and run them differently. This threat has been sufficiently felt by many managements to get them to lobby state governments to pass laws impeding this process, But these outside investors have both the incentives and the expertise available to evaluate a corporation's efficiency better than most of the rank and file stockholders can. Complaints that corporations are undemocratic miss the point that stockholders may not want them to be democratic, and neither may consumers, despite the efforts of people who call themselves consumer advocates to promote laws that would force corporations to cede management controls to either stockholders or to outsiders who proclaim themselves representatives of the public interest. The very reason for the existence of any business enterprise is that those who run such enterprises know how to perform the functions necessary to the organization's survival and well-being better than outsiders with no financial stake, and with no expertise being required for calling themselves consumer advocates or public interest organizations. Significantly, attempts by various activists to create greater stockholder input into such things as the compensation of chief executive officers have been opposed by mutual funds holding corporate stock. These mutual funds do not want their huge investments in corporations jeopardized by people whose track record, skills, and agendas are unlikely to serve the purposes of corporations. The economic fate of a corporation, like that of other business enterprises, is ultimately controlled by innumerable individual consumers. But most consumers may be no more interested in taking on management responsibility than stockholders are. Nor is it enough that those consumers who don't want to be bothered don't have to be. The very existence of enhanced powers for non-management individuals to have a say in the running of a corporation would force other consumers and stockholders to either take time to represent their own views and interests in this process, or risk having people with other agendas override their interests and interfere with the management of the enterprise, without these outsiders having to pay any price for being wrong. Different countries have different laws regarding the legal rights of corporate stockholders, and with very different results. According to a professor of law who has specialized in the study of business organizations, writing in the Wall Street Journal, American corporate law severely limits shareholders' rights. So does Japanese, German, and French corporate law. In contrast, the United Kingdom seems a paradise for shareholders. In the UK, shareholders can call a meeting to remove the board of directors at any time. They can pass resolutions telling boards to take certain actions. They are entitled to vote on dividends and CEO pay, and they can force a board to accept a hostile takeover bid the board would prefer to reject. How does the economic performance of British corporations compare with that of corporations in other countries? According to the British magazine The Economist, 13 of the world's 30 largest corporations are American, 6 are Japanese, and 3 each are German and French. Only 1 is British, and another is half owned by Britons. Even a small country like the Netherlands has a larger share of the world's largest corporations. Whatever the psychic benefits of stockholder participation in corporate decisions in Britain, its track record of business benefits is unimpressive. Questions about the role of corporations as such are very different from questions about what particular corporations do in particular circumstances. The people who manage corporations run the gamut, from the wisest to the most foolish, and from the most honest to the most dishonest, as do people in other institutions and activities, including people who choose to call themselves consumer advocates or members of public interest organizations or advocates of shareholder democracy. Executive compensation. The average compensation package of the chief executive officers of corporations large enough to be listed in the Standard & Poor's Index was $10 million a year in 2010. While that is much more than most people make, it is also much less than is made by any number of professional athletes and entertainers, not to mention financiers. Some critics have claimed that corporate executives, and especially chief executive officers, CEOs, have been overly generously rewarded by boards of directors carelessly spending the stockholders' money. However, this belief can be tested by comparing the pay of CEOs of public corporations, owned by many stockholders, with the pay of CEOs of corporations owned by a small number of large financial institutions. In the latter case, financiers with their own money at stake set the salaries of CEOs, and it is precisely these kinds of corporations which set the highest salaries for CEOs. Since it is their own money, financiers have no incentive to overpay, but neither do they have any reason to be penny wise and pound foolish when hiring someone to manage a corporation in which they have billions of dollars at stake. Nor do they need to fear the adverse reactions of numerous stockholders who may be susceptible to complaints in the media that corporate executives are paid too much. What has provoked special outcries are the severance packages in the millions of dollars for executives who are let go because of their own failures. However, no one finds it strange that some divorces cost much more than the original wedding cost, or that one spouse or the other can end up being rewarded for being impossible to live with. In the corporate world, it is especially important to end a relationship quickly, even at a cost of millions of dollars for a golden parachute, because keeping a failing CEO on can cost a company billions through the bad decisions that the CEO can continue to make. Delays over the firing of a CEO, whether these are delays within the company or within the courts, can easily cost far more than the golden parachute.